Hi, this is attorney Jamie Miller, and I really am excited to welcome you to another edition of the Miller Law Chronicles. Today, we're going to talk about the intersection of divorce and bankruptcy. And we're going to talk about, does it make sense to file divorce before bankruptcy? Does it make sense to file bankruptcy before divorce? And the pros and the cons of doing so. It's an issue that we deal with all the time, and I'm excited to share some information with you that could help you and could impact your decision as to when you're going to file divorce or bankruptcy. I hope you're enjoying the Miller Law Chronicle podcast. I'm really enjoying my time putting this together. Please like us, subscribe to us, give us a thumbs up. Give us some chat time in the box below. Happy to hear from you. And again, thank you very much for your valuable time listening to the Miller Law Chronicles podcast. Thank you. Hi, this is attorney Jamie Miller, and welcome to another edition of the Miller Law Chronicles. Today, we're going to spend a few minutes and we're going to talk about the intersection of divorce and bankruptcy. We often at Miller & Miller have clients that come to us that are in the middle of a divorce and then need to file for bankruptcy, or they have filed for bankruptcy and need to file for divorce after the bankruptcy is filed. These are all issues that we're well trained to deal with and to navigate, but it's important to understand the nuances of both and exactly how they intersect. So from a Wisconsin perspective, Wisconsin is a marital property state. In the state of Wisconsin, only spouses can file for bankruptcy jointly. So if you're not married, if you just have a significant other and you don't have any sort of marital ceremony or marital contract, you can't file a joint bankruptcy. You have to be married to file together. Wisconsin is a marital property state, which means when one spouse files for bankruptcy, the assets of the other, the non-filing spouse, we call it, are assets of the bankruptcy estate. We have something called the supremacy clause. So the supremacy clause says that the bankruptcy supersedes the state court law. So you get divorced in Wisconsin in state court. So as we're navigating the competing issues between the federal bankruptcy court and the divorce state court, we start from the presumption that the federal bankruptcy law is supreme. So for instance, in the bankruptcy rules, debts that are part of a divorce settlement may not be discharged. So for instance, if there's guardian ad litem fees that are ordered as part of a divorce that one spouse, doesn't have to pay for, the bankruptcy could discharge that. When one files for bankruptcy, there is a bankruptcy force. It's called the property of the bankruptcy estate. The estate is created when a bankruptcy case is filed. There's assets of the marriage kind of fictionally go into the bankruptcy estate, and they come out of the bankruptcy estate once a bankruptcy is finished, or when we assert exemption laws. Now, let me talk to you more about that. So if you own real estate, if you have a car, if you have household goods, when you file bankruptcy, those assets are all fictionally turned over to the bankruptcy trustee. The trustee evaluates those assets and determines whether or not they are all protected. Once it is determined that they're all protected, the trustee abandons the assets and doesn't claim any interest in those assets. So it's important to understand that, because in Wisconsin, if you're married and you have one spouse that doesn't join in the bankruptcy, the non-filing spouse's assets are part of the bankruptcy estate until the trustee abandons those assets because they might be exempt or protected, or until the bankruptcy case closes. So that's really important to know, because there's exemption laws. A debtor can remove items from the bankruptcy estate by asserting exemptions. So those exemptions come from the federal statutes or state statutes that says you can keep your home up to a certain dollar amount. You can keep your car up to a certain amount. You can keep your household goods up to a certain amount. So it's important to make sure that we pay attention to that. Now, when one files for a divorce, and as part of the divorce, it is ordered that certain debts be paid for by one of the spouses, and that spouse has filed for bankruptcy, there's certain debts that can't be discharged in bankruptcy. And that's really one of the important things that we have to understand. So in general terms, when someone files for bankruptcy, you can't discharge debts that are incurred by fraud, conversion, embezzlement, breach of fiduciary duty, or debts resulting from willful or malicious behavior. So if you are in a car accident, for instance, and there's drunk driving that results in personal injury, that drunk driving personal injury may not necessarily or will not be discharged in bankruptcy. If someone steals from an employer and it's willful and malicious and intentional, and that employer has a judgment against that employee, and the employee tries to file for bankruptcy, that debt is not something that's dischargeable because it was intentional. So there are items that aren't discharged as part of a bankruptcy, and those items would be anything that's in the nature of child support.